Hi, welcome back to the channel. This is the Homeschool Dev, back at you with another video. And today I'll be discussing how had to become a pro se litigant in a housing dispute, advocating for myself and my family. But first, I want to show you the non-HUD tenant-based rental agreement, and this is a copy of that document. Um, And I just want to run through a couple of things right quick before I start getting into how and why I became a pro se litigant. I already have the script for that written out, and the reason for that is that I want to be very detailed and descriptive in giving the actual facts. And plus, I think I can add more value to this content in regards to the deliverance of the message. But here is the tenant-based rental agreement. Uh, I believe there's 5 pages, and here in the, would be the management company, the address where you would be living at, and then your name would be here. And then you have the terms of contract. You have the some other things like the security deposit. And if we click here, uh, there are some other details. Here, right here is the most important, one of the most important details. There's two things on here that I would like to stress upon you that are really crucial. The housing quality standard and property partner provided service. Now, this section goes over the housing quality inspections. And when you have a non-HUD tenant-based rental agreement, right? The housing quality inspections have to be done in your unit before this contract actually is a legal binding document. So if your housing quality inspection doesn't pass, then the landlord, neither the uh, housing voucher agency can move forward with payment or moving you into the unit. Now, it's at the housing agency's discretion to schedule these housing quality inspections, and they usually happen annually at the end of your lease, or they may decide to do it, whenever they would like to schedule one. The next part of the tenant-based rental agreement that's important is the fair housing right requirements. And the reason why that's important is because, say for instance, you don't have a housing quality inspection and the housing agency passes the unit and then pays the realty company on your behalf, then that's a violation of the Fair Housing Act because you're living in a substandard unit that hasn't actually passed, and so they're violating federal guidelines, which are the Fair Housing Guidelines. They cannot pay the management company, they cannot inspect the unit and then pass the unit as being inspected and pay the housing management company and move you in. Then, if that happens, then you have several laws that fall under the Fair Housing Act that you can um, file a complaint against the management company or the uh, housing voucher company. Here we have the rights for the housing voucher agency if the landlord breaches the contract. Now, the landlord can breach the contract in several ways, and one ways I want to stress is that if the unit doesn't pass inspection and the landlord decides not to fix or delay the maintenance issues, then the housing voucher agency can deem the contract as a breach, and they would have to stop payment to the landlord. Even if you agree to stay in that unit, the housing voucher agency can just terminate the contract, terminate payments, and typically that's what you would want to have happen, especially if the landlord is delaying or fixing or not fixing issues in the unit, right? You would not want to be in that unit anyway. And that's what happened in my case. The housing voucher agency actually performed the housing quality inspection and passed the unit and continued to pay the landlord. But I called the city's code enforcement after they passed the unit as inspected, and the city's housing code enforcement found that my unit was substandard. And I'll get into that in a minute because that's one of the reasons that I became a pro se litigant. Now, here's the final page, and, and on the first page, if you remember, uh, my name was on the document. It was the realty company and the address, and then the tenant's name. But if you look on this document, only the landlord and the housing voucher agency signs the document. Now, I find that kind of odd because if your name is on the document and this document is a legal binding document, then we should have a space where our names, the tenant's names, can sign. But because they don't have that, then you legally don't have any cause to file any complaints because you don't have a signature block, you're not binded to this contract. And that is something that I'm fighting for and advocating for that needs to change. Um, so let's get to um, the reasons why um, I became a pro se litigant. And once again, this is the Homeschool Dev. Please like, share, subscribe to the video. I would appreciate that. So let's get into it. Um, Jerry Smith, which is myself, that's my real name. I became a pro se litigant representing myself in court due to several factors tied to housing situation and the failures of the system designed to protect tenants. Number one, lack of legal support or resources. Limited access to legal aid. Many tenants, especially those experiencing homelessness or housing insecurity, struggle to access affordable or free legal representation. Organizations offering such services may be overwhelmed, underfunded, or have strict eligibility requirements. Now, in my case, I went to several lawyers in the state of New Mexico, and they didn't even want to touch the case. And so legal aid right, explained to me that they were underfunded. And so they couldn't really advocate on my behalf the way I wanted them to. Non-HUD tenant-based rental agreement complexity. Because of my non-HUD tenant-based rental agreement and assistance contract falls outside of HUD's jurisdiction, traditional housing advocacy groups or legal aid may have been less equipped or willing to handle the case. And that's exactly what will happen. Because your contract non-HUD tenant-based rental agreement is not a HUD contract and they don't have jurisdiction, most attorneys, most lawyer advocacy groups will not move forward with your case. Systemic failures and bureaucratic roadblocks. Failure of the housing voucher agency and the realty company, despite reporting substandard living conditions to my housing voucher agency and the landlord, my concerns were ignored after reporting several issues with the unit, the housing voucher agency, and the tenant and the landlord actually retaliated against me because I made complaints of the habitability issues in the unit. So my concerns were ignored. The housing voucher agency failed to inspect my unit now listen to this, between the years 2015 and 2023. That's a long time. And even after, they came back to inspect the unit in 2023 to recertify me for a new lease, and they actually passed the unit, I had to call the city's code enforcement. And after I called the city's code enforcement, they deemed that my unit was substandard, unhabitable to live in. Ain't that something? So the housing voucher agency continued to pay the landlord rent. Retaliation and voucher termination. When I persisted in raising the issues, the housing voucher agency terminated my housing voucher rather than addressing the problems or facilitating my relocation, which I was promised. I met with the CEO of the housing voucher agency to discuss, all the issues with my unit prior to me calling code enforcement, prior to me having the CEO come out to inspect my unit herself. And they did not facilitate my reasonable accommodations request for relocation. And so it became a big mess. And this is why I was forced into a situation where legal action was necessary to protect my rights and secure housing. Jurisdictional gaps and lack of accountability. HUD's limited jurisdiction. When I contacted HUD, I was informed that my contract was a non-HUD tenant-based rental agreement, placing it outside of HUD's authority, and this left me with fewer regulatory protections and oversight mechanisms. And at first, when I called HUD, I was confused about them saying that they didn't have jurisdiction over that contract, because the main reason is I never heard of a non-HUD tenant-based rental agreement. And I was never told about that non-HUD tenant-based rental agreement. And I was in the program for 10 years. I never was introduced to the document. I didn't have privy to the document. And The only reason I was able to obtain a copy of it was because after everything fell apart and I was terminated, I requested a copy of that non-HUD tenant-based rental agreement. I even contacted Fair Housing, and Fair Housing has limitations. Fair Housing investigations found no evidence of discrimination or retaliation, labeling the issue as programmatic rather than legal violations, leaving me with no recourse through traditional housing discrimination channels. Now, I feel that I was strongly discriminated against and retaliated against. And so these are some of the issues, uh, nuances in my case that are being appealed, and they are even being disputed, as I shoot this video. Determination to seek justice and hold agencies accountable. Um, I really find it hard and mistrust housing voucher agencies because this is the second time something like this has happened with me and my family with housing voucher agencies. And the second time, at that point, I had enough of it. And the severity of the neglect and intentional discrimination after calling HUD and Fair Housing and all of the attorneys, it just made me more angry and more determined to advocate for myself and my family no matter what my learning curve was. So my decision to represent myself had to stem from my desires to hold the housing voucher agency, the realty company, and the city and all of the funders accountable for the systemic failures, including their mishandling of inspections, improper lease agreements, and wrongful voucher termination. Now, this case will set precedents for housing justice, because by me becoming a pro se litigant, uh, my aim is to set a precedent not for just myself, but for other tenants facing similar struggles in non-HUD tenant-based rental agreement contracts and rental assistance programs, and that's over 2.3 million people across the country. And a little tidbit, the non-tenant based rental agreement has never been disputed in the court of law, and especially in the Court of Appeals or the Supreme Court. And so I've already started that process in the appeals process where the Court of Appeals will be looking at the cases that I have appealed. And in summary, I became a pro se litigant due to a combination of lack of legal resources, systemic neglect by housing agencies, and jurisdictional loopholes that left me with no other options but to represent myself. My case highlights the broader issues of tenant vulnerability in non-HUD housing programs and the urgent need for greater accountability and tenant protection. I hope this video has brought you some value, and please, if you know or have been any experience in dealing with the housing voucher agency or a landlord who you had trouble with in regards to fixing your maintenance issues or substandard issues in your unit, please leave a reply in the comment section below. This is the Homeschool Dev. Please like, share, subscribe to the videos, and I'll see you in the next one.